Good morning and welcome to today's webinar, The Secure Act, 1 year later, how it will impact your estate planning and retirement, presented by Elville and Associates Managing Principal and Lead Attorney, Stephen Elville. My name is Jeff Stauffer, Community Relations Director with Elville and Associates, and I'll be moderating today's event. So how this will work today, if you're new to our webinars, if you are, welcome, we're glad you're here. You as the attendee are in listen-only mode. However, you do have a voice. When you have questions, please note them in the questions panel on the right-hand portion of your screen, and we will take time throughout to address them. You also received the presentation yesterday by email from me to take notes on it if you wish. If for some reason you did not receive this presentation from me, it is available currently in the section marked Handouts in the panel on your screen. For CFPs, CPAs, and various other professionals on today's webinar, you may receive 1.5 continuing education hours for attending. For attendance records requirements, please email me your ID number. And for CFPs only, I also must have the last 4 digits of your social security number as soon as possible so I can submit your CE hours for approval. Everyone will also receive a post-webinar feedback email right after the presentation. And we do ask that you do take just a couple minutes to fill out this simple survey to offer us your feedback about the presentation. It's also an ideal time to request a consultation with Steve for planning needs that your family and you may have, for a free consultation to get started, or for document reviews, or for any other matters that you may have. And we always look forward to being a resource for you and your family now and in the future. So I'd like to give you a little bit of a background about Steve and Elville and Associates. If you're new to us or just need a little bit of a refresher. So Elville and Associates, founded in 2010 by Managing Principal and Lead Attorney Stephen Elville in Columbia. We are coming to you live from the Columbia location here in the Columbia Gateway community. We have a number of different practice areas that we offer here at the firm, including estate and special needs planning, elder law and elder care planning, estate and trust administration, business law and succession planning, guardianship and litigation, and tax planning and asset protection. We have 7 attorneys, 12 staff members, and 5 locations. Our mission, as it always has been and always will be, is to provide practical solutions to our clients' needs through counseling, education, and the use of superior legal technical knowledge. We do offer a lot of education here at the firm, and we offer that in a number of different ways. That's through our planning processes with our clients. We also offer well over 100 educational webinars and workshops in the communities that we serve each year, and also by way of our accredited client care program. We are one of only 2 firms in Maryland to have an accredited client care program, or CCP as we call it here, accredited by the Client Care Academy in Boston. And it's a program that has a lot of very robust features and benefits that many of our clients take advantage of. And if you'd like to learn more about it, you can email me or email our legal administrator, Mary Gay Kramer, at mary@elvilleassociates.com. We always work with our clients with the ideals of client education, collaboration, and compassion in mind. Every client, every time. So you should always expect nothing less from us anytime that you work with us here at Elville and Associates. A little bit about Steve. His work as an attorney for the past 20+ years has been centered in elder law, special needs planning, and estate planning, with an emphasis in the areas of tax planning and asset protection. A member of a number of very high-level membership organizations such as the National Academy of Elder Law Attorneys, the Academy of Special Needs Planners, and the National Network of Estate Planning Attorneys, just to name a couple. He works to bring peace of mind to clients by creating solutions to their needs through counseling, client education, and the use of leading-edge legal technical knowledge. He was also last year's chair of the Elder Law and Disability Rights Section Council of the Maryland Bar Association. Each year presents at many webinars, workshops for businesses and their employees, conferences, and continuing education events. Is a very seasoned speaker, and also named to the Maryland Super Lawyers list for a 6th time in 2021. So congratulations to Steve. Also had a feature story written about him in the National Super Lawyers magazine about the Elville Center for the Creative Arts, which is our firm's charitable organization he founded in 2014, and I am privileged to be the executive director of. We do a lot of work in the communities that we serve with a lot of school music programs. We partner with the Annapolis Symphony Orchestra and the Columbia Orchestra with their educational initiatives and work to make a difference for a lot of student musicians that are in need. So if you'd like to learn more about that, you can always email me at jeff@elvilleassociates.com. If you'd like to meet with us about the Elville Center, you can also email me, and we're happy to speak further with you about that anytime. So with that being said, we're going to go ahead and get started. And I want to start off with a real brief poll to get an idea of what has brought you to this webinar today about the Secure Act. And I want to get an idea of what your knowledge is about the Secure Act. So I always can't find my paper about it, so that's okay. So the question is, how familiar are you with the Secure Act? And I'm going to launch this poll. You should see it pop up on your screen. And the answers, and choose the one that best describes you, is, what in the world is the Secure Act? Secondly, I've read about it and know the very basics of the Secure Act. Or thirdly, I've studied it, feel educated, and am here to learn a bit more. So choose the answer that best fits your current situation, and we'll give it about 30 seconds or so. And then we will jump into the presentation. Okay, we already have about 80% of the ballots having been cast. We'll give it a few more seconds. Okay, so we have 27% of people saying, what in the world is the Secure Act? That's a good question, and that's going to be answered. 57% saying, I have read about it and know the very basics. And another 19% saying, I have studied it, feel educated, and am here to learn a bit more. So thanks for participating. And I'm going to go ahead and turn the reins over to Steve. I'm going to take a second to change presenters. Steve, you should see that button pop up on your screen.
See it, Jeff. Thank you.
Okay.
And I'm going to bring up the presentation.
There we go.
And I think I'm going to be in control of the screen. Thank you so much, Jeff. And good morning, everyone. Spring greetings to everyone. And greetings here from Elville and Associates here in Columbia, Maryland. We're sending you positive vibrations today as you spend a little bit of your precious time with us. We appreciate it, and we appreciate you supporting our event here today and all of our events. And as we are in this post-COVID environment, at least in our part of the world, we're feeling very blessed, and we hope you are too. We hope you and yours are safe and well, although we know many people in some parts of the world are still very much embroiled in the COVID crisis. So we always want to be mindful of that. And I want to thank Jeff for my colleague and friend here at Elville and Associates, without whom I could not put on these workshops. And so Jeff, thank you very much for all you do. And Jeff is here on the webinar to take any questions that you have as we go through. We're certainly going to stop and answer questions as much as we can going through. We're going to end on time, however. And I just want you to know that Jeff and I will be stopping. He is a wonderful moderator, and he will be taking questions and providing information as we go through. I also want to say it's Jeff's birthday coming up, so happy birthday, Jeff, in advance on May 30th. What are we doing here today? Thank you. You're welcome, Jeff. So thank you, and again, and what are we doing here talking about the Secure Act 1 year later? Well, what I want you to do with this workshop is I want you, if you are not an advisor, if you are a client or a potential client of someone on this webinar or of Elville and Associates, I want you to learn. I want you to take this under advisement, of course. But the whole purpose of this presentation, in my opinion, is not just to get more of facts or get more of your mind around the Secure Act, although that's exactly what we're going to do. The purpose in my mind is to get you to take action as far as updating estate planning documents, but maybe even more importantly or equally important, to engage with your advisory team, to engage with your financial advisor, your CPA, and your estate planning attorney as a collaborative team to really analyze your situation, look at the numbers, look at the solutions that are available to you, and not just fact find here. We want you to actually do some analysis and utilize the tools that are available to you with your financial advisor, with your CPA. So that's what I want you to really take away from. Now, as I get ready to launch into this presentation, I want you to know that I recently attended the Heckerling Conference, which we usually attend in January, but this year it was in May, and it was virtual, unfortunately. But we did get to hear the great Natalie Choate, who in our world is the #1 authority on retirement planning and estate planning. And she is just a wonderful resource. So I have read as much as I can of her treatise, which is about 2 or 3 inches thick. I still have a lot more reading to do, but I come to you today primed and ready after reading Natalie's material. So let's go ahead and get started in the material, and thank you again for being here. So today, what are we going to talk about? Well, we're going to talk about a very basic overview about the Secure Act. Now, many of you who have looked at this know the Secure Act is not just about the 10-year rule and all of the things we're going to talk about that affect retirement plan assets and estate planning. The Secure Act was much broader than that. And so just know that there are many, many features of this legislation that we're not going to talk about today. We're going to focus on how retirement plan assets are affected by the Secure Act as they relate to estate planning. Who is affected, and who is exempt, and who is not affected, so forth, and so on. What do I need to do about the Secure Act, and other important questions? So we're going to talk about what should you do as far as estate planning with regard to the Secure Act, but then a much broader question, because the estate planning adjustments that can be made, meaning the document type adjustments, those are pretty straightforward. In most cases, those are things that can be handled, they can be drafted, they can be explained and executed. That's not a problem in most cases. It's just a matter of due diligence. But the broader questions are, what do we do about the accelerated taxation for most people? So that's what we're going to get into. And again, what are the estate and retirement planning implications of the Secure Act, and what are the next steps? So we don't want to just provide information. We want to urge you, we want to provide a path forward to actually look at analyses and in practical terms, take next steps now that the Secure Act is over a year old. So what is the Secure Act? Well, again, I mentioned a few minutes ago, it's a very broad piece of legislation that enhances, in most cases, retirement planning for Americans, and there's been some more amendments to the Secure Act. But basically, the Secure Act is an acceleration of taxation, and it was implemented in December of 2019, signed by President Trump in January of 2020. And it has broad-reaching implications that the estate planning community took about 3 or 4 months after January of 2020 to catch up. I was just speaking with a client this morning, bright and early, who had done estate planning right at the beginning of January 2020, and the Secure Act had just come out or was just getting ready to come out, and we are just now, in this particular case, catching up with this particular client's planning as it relates to the Secure Act. So the Secure Act is going to have broad-reaching implications to tax trillions of dollars of retirement plan funds much sooner, much quicker, on an accelerated basis. Now, at the same time with the Secure Act, what do we know that is going on in Congress? Well, for those of you who may have seen a recent webinar that we talked about the major tax acts that are being proposed, starting with the 99.5% Act by Senator Sanders on March 25th, followed by the Van Hollen STEP Act on March 28th, and then a month later, President Biden's American Family Plan. So what is going to happen? We don't know what's going to happen for estate tax. We really don't know, even though Senator Sanders' proposal proposed a cut to $3.5 million per person on the federal exemption level instead of the $11.7 million that we have now. If that happened, it certainly would affect the state estate tax in Maryland. And in my view, the state estate tax exemption in Maryland, which is $5 million, probably would be reduced to $1 million. So it would have far-reaching implications. But my understanding is that the American Family Plan right now is putting the reduction of the estate tax exemptions on hold. And I don't know whether that's going to kind of resurface at the end of the summer with the proposed legislation being mostly focused on income tax. So as we look at the Secure Act here and how it's going to accelerate income taxation and put a lot of taxable income into the taxable estates as far as income tax of beneficiaries, these beneficiaries in the future may be facing higher income tax rates, which they most likely will, up to about 39.6% and so forth from 37%. We're going to look at that. There may be a loss of the step up in basis based on the Sanders Act, the Van Hollen Act, and the American Family Plan, which Janet Yellen has said the #1 goal tax-wise of the Biden administration is the elimination of the step up in basis. So I throw all that out, not that that has anything directly to do with the Secure Act, but I throw that out to say that the Secure Act, as it relates to the acceleration of income tax, we have to be mindful that a lot of legislation is being proposed to raise taxes and then expose more people probably down the road to estate tax, and juxtapose that with the acceleration of income tax posed by the Secure Act. Now, one more thing about the Secure Act, about the American Families Plan and the Van Hollen proposals and the Sanders proposals. One consistent thing with these proposals, at least with the Sanders and the American Families Plan, is a limitation on the use of grantor trusts. Now, Steve, what has that got to do with Secure Act? Remember, a grantor trust, a basic example is a revocable trust. But another basic example of a grantor trust is a life insurance trust. So what we're going to see in this presentation, and what I'm going to urge, is that as you look at what the Secure Act may do to affect your estate planning, that you take very seriously the notion of using life insurance as a tool to preserve wealth, given the fact that the Secure Act and the other tax proposals on the table are definitely going to take away the wealth, some of the wealth at least, that has been accumulated over the last 10 or 20 years. And remember that the use of life insurance trusts, or what we call ILITs, the irrevocable life insurance trust, the common use of those trusts may be altered forever with the new legislation that has nothing to do with the Secure Act. But it just means that if you kind of get on the bandwagon to analyze your estate, your tax planning, your financial planning as it relates to the Secure Act, and don't forget to juxtapose that with the potentiality of the tax increases that are being proposed and the limitations on grantor trusts, it may be that if you need to use life insurance to preserve the wealth that is otherwise going to be reduced by the Secure Act, you may want to implement that life insurance plan and that grantor trust, which is the irrevocable life insurance trust. There may be a strong reason that you would need to implement that in 2021, before the end of 2021. So we just don't know. Some of the proposals may be retroactive. Some of the acts may not be retroactive, and hopefully not anymore in place prior to their date of enactment, or January 1st, 2022. So that's a lot to say at the very beginning, but in all honesty, there's a lot going on. So as we look at this material, remember the analysis of your estate planning and retirement planning as it relates to the Secure Act is only one aspect that must be juxtaposed with the other tax increases that are being proposed in the Biden American Families Plan. Now, who is affected by the Secure Act as we get going here? Well, person who is a person or persons who are planning for, their estate planning, and their retirement plan is focused on what we were focused on for years. And what was that? That was the stretching out. That was the tax deferral of what we would call a conduit trust. This is where we leave assets to a beneficiary. This does not have anything to do with spouses. This is a legacy that we leave from a qualified plan or an IRA to a beneficiary. And that beneficiary is a child, niece or nephew, grandchild, whoever it may be. And what do we know? We know that we could stretch that out. If we did nothing but take minimum distributions, we could stretch that out to a very old age, into the age 80 range of the child or the other beneficiary. And so that was a wonderful thing. And that has now been eliminated by the Secure Act, except for a very limited number of people. And then number 2 bullet point here, persons for whom estate planning for their retirement involves beneficiary designating their retirement plan to the conduit trust, which is what I was just saying. So the person who is focused on maximizing the tax deferral, that person is now being affected by the Secure Act. And this is whether we are leaving assets outright to beneficiaries or whether we are leaving assets in trust for beneficiaries, which many of you do. Now, who is exempt? This is the good news, but it's not that great. The surviving spouse is exempt. So the surviving spouse of a plan participant is exempt. Minor children are exempt until they are age 18. Disabled persons, now this is a person with disabilities, or maybe what we might call a special needs beneficiary. This is a person who is exempt. They can still stretch out the IRA when they receive the inherited IRA. They can stretch it out for their life expectancy. We have to be very careful, but they do have the right to do this. And what do we know about most disabled persons who would receive an IRA? They would receive that in a special needs trust, or what we might call a supplemental needs trust. So we know the disabled person themselves are exempt and their special needs trust is exempt. So that special needs trust has to be drafted properly, or what? Well, even though this disabled person is exempt, if that special needs trust is not drafted properly, they actually could be deemed to have the default rule, which is the 5-year rule. So they would go from having full life expectancy payout, which very few people can have these days, to having the worst of all worlds, which is a 5-year rule. So this might be time for me to explain, for those of you who have never heard of the Secure Act, what I'm talking about in a little bit more detail. So prior to the Secure Act, there were 2 types of beneficiaries who could receive a retirement plan, an IRA or qualified plan, as an inherited IRA. This is someone called a designated beneficiary. The designated beneficiary could receive the IRA assets, and if it was left to them outright, or if it was left through a trust, and if that trust qualified as what is called a see-through trust, then that person could stretch out the minimum distributions for their entire life expectancy according to the IRS code. Now, the other type of beneficiary in those days was called the non-designated beneficiary. Now, this is the person who would only get 5 years. This could be an estate, okay, or it would be someone who was non-exempt, and that person or that entity receives the IRA, and now it has to be paid out in 5 years. So now with the Secure Act, we not only have the 2 prior types of beneficiaries, we have 3 classes of beneficiaries. We have the designated beneficiary, just like the old days, except the designated beneficiary can now only stretch out the IRA for 10 years. So they have to take all the assets out of that IRA in no longer than 10 years. Then we still have the non-designated beneficiary, which is the person or the entity, the estate, that has to take out the retirement plan assets in no more than 5 years. But now that we're talking about disabled persons, we're talking about the new class of beneficiary called the eligible designated beneficiary. So we now have a new class, the eligible designated beneficiary. All of these exemptions, all of these people here, these types of persons are eligible designated beneficiaries. They are not designated beneficiaries or non-designated beneficiaries. But in the case of a disabled person, even though they are eligible designated beneficiary, we have to make sure in the drafting of a special needs trust that we don't trigger the worst of all worlds, which is for them to be considered a non-designated beneficiary, which is easy to do. So that's something that has to be thought about. Chronically ill persons are defined in the code. This is a very strict definition. A chronically ill person or someone who has a special needs trust who is chronically ill, those persons are exempt. And then a very strange category, persons who are less than 10 years younger. So let's say that someone is 60 years old and they have a sibling who's 53. That sibling is only 7 years younger. If that participant leaves that beneficiary an IRA, that beneficiary is exempt from the Secure Act because they are less than 10 years younger. Now, if that 60-year-old participant were to leave the asset to their older sibling who was 62, that person is also exempt. So this is a very subtle category, but I've seen it used in the last year as a very advantageous exemption. Who is not affected by the Secure Act for estate planning purposes? Persons who don't own any IRAs or qualified plans, obviously, or persons who would leave their retirement plan benefits to charity. So those of you who are charitably inclined, it's a very powerful way to avoid the accelerated taxation that's going to happen under the Secure Act. So Jeff, we've been going just a little bit here, and I'm going to just stop and see if anyone has any questions.
Thank you, Steve. Currently, no questions. I'm sure there will be, but I will keep you posted.
Very good. Thank you. Now, as I continue to go on so we can finish on time, let's talk about the two threshold questions if we are talking about an estate planning client, someone who has financial assets, they have an advisory team, or they should anyway, and this person is similar to the person I talked to this morning. They're following up, they're doing their due diligence, they're wanting to talk about the changes that are coming in the tax laws, they want to make sure they haven't missed anything. What are the main questions to consider? Well, when we're looking at estate planning documents, we need to determine whether any changes need to be made, and we're going to be talking about what those fairly simple changes could be in someone's estate planning documents. And then the second question for this client is to determine whether they want to or should address the income tax impacts of the Secure Act, and of course the other ancillary impacts that I've just been talking about on their retirement planning assets and their non-exempt beneficiaries. Now, what do I mean by that? That is the vast majority of people that are healthy and well, our children, our grandchildren, our nieces and nephews, or other beneficiaries who do not have a disability. They're not spouses, they're not less than 10 years younger. They don't meet any of the chronically ill or disabled categories. These are just what we would call our normal healthy beneficiaries. What is going to be the impact on them? What does the acceleration of income tax look like? What does the loss of tax deferral look like? The loss of potential asset protection? What does all that look like? Those are the two threshold questions. Now, there are other important questions, and one of the risks of presentations like this is that it's too broad and too much information and too short of a time. But I'm going to go ahead and plow through these other important initial questions. Who are, jumping off of that last slide, those two initial questions, pretty simple. Do I need to make any estate planning changes? And two, what are the tax ramifications that are going to affect my planning? Two basic questions. Now, here are the other related questions. who are my intended beneficiaries and how many are there? So who is the beneficiary is a big deal because, for example, what if we are talking to a client that has 2 healthy children? In the last 24 to 48 hours, I've talked to 2 families like this. There are 1 or 2 neurotypical healthy children, and then there is a disabled child with some kind of issues. And should we leave all of our retirement assets or the vast majority of them to the disabled child who is exempt? So who are those beneficiaries? How many are there? Okay. Should their retirement plan assets be directed to one particular person? And that is what I just mentioned. Is there an eligible designated beneficiary, an EDB? This is the new category. Is there one of those people in the mix somewhere in the family? Are any of the beneficiaries of this particular client or their ideas about beneficiaries potentially a charity? So should we leave retirement plans to charity? We all know that a direct gift of a retirement plan to charity is very powerful. And should we leave non-retirement assets to individuals? And if we don't have enough non-retirement assets, should we create cash through life insurance? And we're going to talk about that. Another ancillary question, for beneficiaries who will receive retirement plan assets, should the person be named directly or should it be held in trust? So let's talk about outright distribution, and this is very fundamental. So should that retirement plan just be kept very simple, beneficiary form designated to that beneficiary, very simple, and I'm making the assumption that this person is a typical healthy person with no disabilities. That's a very simple approach. There is a 10-year payout. That beneficiary is going to have to take out that money at the end of 10 years. There's no question. It's all going to be taxed at that time if it hasn't been taxed already, if it hasn't been used already. And now, what if we do that? We're avoiding any possibility of triggering the 5-year payout as a non-designated beneficiary. So the outright distribution is pretty appealing, even though now our children, grandchildren, and other beneficiaries are going to be accelerated as far as their income taxation upon them. But, and I apologize, that 3 should be moved over to the left. I apologize. What if we do have someone with behavior or lifestyle problems, drug abuse or alcohol, spendthrift tendencies? Okay, now we're possibly not thinking that outright distribution is that great because there's a need to control behavior, lifestyle, or the person has disabilities. So let's talk about the benefits of distributing retirement plan assets into trust. And for those of you who have never known this or thought about this, I'm just going to illustrate with my hands. We have the IRA or 401k qualified plan type assets coming to a trust. This is typically a trust at your death that is for a spouse, or in this particular case, because of the Secure Act, we're talking about how it affects beneficiaries generally, although I don't want to gloss over that. For those of you on this call who might leave retirement plan assets for the benefit of a spouse in a marital trust, let's say, a Q-tip trust, that kind of situation, that trust should be, as we get into the discussion of trust, that trust should be a conduit trust. And that way, we take advantage of the current law and we don't have that non-designated beneficiary status. But let's get back to children and grandchildren and so forth. What are we doing in trusts? Creditor protection, protection against general creditors and bankruptcy, protection against divorcing spouses. So this is one of the main reasons to leave a retirement plan into a trust. About 12, 13 years ago or more, the Supreme Court ruled that inherited IRAs have no asset protection. That living IRAs or 401ks, of course, you have asset protection in your plan. But when you leave it to a beneficiary, they do not have asset protection if you leave it to them in an inherited IRA, which is generally how assets are going to be left to beneficiaries other than a spouse. So to give them protection against divorcing spouses and bankruptcy and so forth, we generally think in terms of leaving those assets in a trust. Now, when we do, what do we have? We have offsetting advantages and disadvantages. We have maintenance and upkeep. That trust has to file what? A Form 1041, a fiduciary tax return. So that's going to be a maintenance and upkeep issue. The trust is going to be in a 37% tax bracket at only $13,050 worth of taxable income. That's the latest figure for those of you who have not seen that. Now, just to illustrate how that is a very serious thing to have to deal with, individuals in today's world in the tax brackets earn $523,600 to be in a top 37% tax bracket. And of course, couples have to earn $628,300 to be in the highest tax bracket. Now, of course, we know the Biden proposal is to raise this to 39.6 again, as it used to be. So if we're going to use trusts, we have to know how to manage those trusts and the tax income. And we also want to think in terms of reducing the impact. So lest I go beyond where I want you to really be right now in your thinking, I want you to remember that for those of you with larger IRAs, whether you leave it in trust or not, it's very likely that your beneficiary will still be in the top income tax bracket. So that's going to take a little while to sink in, but I want you to know that just because you leave it in a trust does not necessarily mean it will be taxed higher than if you leave it to the individual, because that individual could still very well be in the top tax bracket, especially if they do not take all the assets out within 10 years. Now, if we leave assets in a trust for a beneficiary, it's almost guaranteed that we will be in a 37% tax bracket. So we're going to talk about this, but I just want you to know that a trust does not necessarily mean it will be higher than the individual, although we do know it will be at the highest rate most likely, and we have to think in terms of how are we going to deal with that. All right, number 3, if a retirement plan is left to a trust for the benefit, is the cost of the trust worth the price? So there's that maintenance and upkeep I just talked to you about, the 37% or the 39.6% bracket. And we have to realize that there is a price for that, okay? If the child has a trust that which we're going to talk about in a few minutes, where we trap the assets inside of that trust, this is one of the strategies of the Secure Act to deal with the Secure Act. In other words, we don't want those assets to escape, which we're going to talk about in just a minute. Then we're not only talking about high income tax bracket, during the lifetime of the first 10 years of the IRA, we're talking about high income tax brackets that will have to be managed after the first 10 years if that money is taxed and then remains in the trust. Should a retirement plan be drawn down or converted to Roth during life? Okay, the part about drawing down the IRA, just get it all out of the IRA, that was something that was never considered ever. And now that is actually a viable option, although I don't know if it's really that recommended, but it is an option to simply not deal with this at all, draw all the money out of the IRA. But I think that's just something to philosophically consider. And most people are going to be thinking in terms of the several strategies I will show you here in just a moment about dealing with the tax. So is there a way to avoid the destruction of the retirement plan after death? And if we do that, if we use a trust, what is the liability of the trustee amidst all of these complicated rules? And should we release the trustee of liability when it comes to dealing with all of these complex rules? So these are the considerations as we get into the more meat of the material. So as I mentioned, the Secure Act was effective January 1st, 2020, signed into law in December of 2019 by President Trump. Let's take this chart as an example. The conduit trust, as you may recall, is the trust that was always used. There was always this conduit provision for the last 50 years, I would say, where people who wanted to leave an IRA in trust would simply say, my beneficiary will get minimum distributions, bare minimum, and that minimum distribution must be distributed out. It must be distributed out immediately. If there is a distribution into the trust from my IRA, the minimum distribution, it must be distributed out. Now, that was a very, very good strategy. Many clients on this call have that plan right now, and that's what we always did, because the balance of the IRA remains in the trust and is protected from creditors and divorcing spouses and so forth. So that was a wonderful way of dealing with it, and Uncle Sam was happy because Uncle Sam gets to tax the minimum distribution. But now that has all changed because of the 10-year rule. So my point in this illustration is this: if we have conduit provisions, which is that provision that allows that minimum distribution to be forced out and taxed to the beneficiary, but everything else can be in the trust and protected. If we don't change that under the new law, at the end of 10 years, if that beneficiary has not taken all of their IRA out, if they are going to take all the distribution and pay all the tax at the end of the 10 years, then what's going to happen is all of the IRA is going to be forced out of the trust. So the conduit provisions are a disaster potential disaster, if we leave the conduit trust provisions the way they are. I'm just going to check my next slide. So I'm not going to focus on these particular illustrations, but this is just to show what would happen if we've got a trust that holds assets and there's no withdrawals for the first 10 years. And then at the end of 10 years, everything is forced out of the conduit trust. So what do? Well, we don't want that. Most parents are saying they don't want that. So we would switch the conduit trust to something called an accumulation trust. Now, we normally would only use an accumulation trust for a special needs beneficiary, someone who is not supposed to be getting distributions outright out of the trust. But most parents and most clients are going to say, no, I don't want all of that IRA money to be forced out as a minimum distribution at the end of 10 years. I don't want that. That could cause a disaster for asset protection. I know the tax is due in 10 years. I'm okay with that, but I want all of the IRA money to be trapped inside of the trust, and it will not escape after 10 years. It will be accumulated, and that way my beneficiary, even though they have to pay all the tax either way, whether it's outright or whether it's in the trust, at least it will not escape the trust and it will not be subject to the claims of creditors or a divorcing spouse. So fixing the conduit provision, so to speak, of a trust is a pretty straightforward thing. That's part of the basic consideration. Do I need to do anything with my estate planning documents? Now, let's talk about managing some of the consequences of the 10-year rule. Jeff, I'll stop just a second and see if we have any questions at this point. I know it's pretty technical.
Thanks, Steve. We do have one question. And that question is, I understand the 10-year rule, but am still not clear on how and when the 5-year rule kicks in. If you could touch on that briefly, please.
Very good. The 5-year rule would kick in if we don't meet the requirements of, and I'll just talk about the estate planning side. Let's say that someone was entitled to a 10-year distribution, and we drafted for an asset from a retirement plan to go into a particular trust. And we did not follow the Secure Act's very funny guidelines that say that we have to address and jump through certain hoops. Even though the person is eligible for the 10-year rule, we didn't jump through those drafting hoops. And therefore, for example, with a spouse, let's say that someone wanted to leave a retirement plan to a a marital trust, a Q-tip trust. And that's a very common thing. I'm leaving my IRA to a marital trust. Well, that marital trust has to be made. Now, this is going to sound contradictory to what I just said about children's trust. But for spouses, it's a little bit different. That marital trust needs to not only be a Q-tip trust, it also needs to be a conduit trust, or otherwise we're going to fail the test. And that's a rule that we'd have to talk about offline. We're going to fail the test for the marital trust And if it's just a plain old Q-tip trust with no conduit provisions, it will not get the 10 years. It'll get the 5 years. Another example would be, I'll give you two more examples. Another example would be what I mentioned about a special needs trust. The disabled person is exempt. The special needs trust for that disabled person is exempt. And so they should get lifetime treatment. But even though that trust is an eligible designated beneficiary and the person themselves is an eligible designated beneficiary, if we don't draft properly in that special needs trust, the eligible designated beneficiary could actually be triggered to be a non-designated beneficiary, causing the worst of all possibilities, which is the 5-year rule. Another example, and I guess the last one I can give, is what if someone were to leave their IRA to an estate? They didn't leave it to an individual, they left it to their estate. Well, the estate is going to be considered a non-designated beneficiary, and that's going to trigger the 5-year rule. So the designated beneficiary, as long as the little nuances of drafting and trusts are not violated, is going to get their 10-year rule. The eligible designated beneficiary will have lifetime treatment, but if the drafting isn't correct, it could trigger a 5-year rule, even though these other folks are eligible for 10 years or for life. All right, so what do we want to do in our planning? We want to retain income tax deferral. We want to manage brackets. We want to fulfill charitable goals with what is called income in respect to a decedent, which is an IRA or qualified plan. And we want to convert ordinary income to capital gain where we can, and we want to manage state income taxes. So I know I've gone a little bit long in the first part of this presentation, so I'm now going to go a little bit faster as we look to these solutions. So there is widely considered to be 4 or 5, and I guess in this slide 6, different solutions that are possible. Now, some of these are more effective than others, and I would say the most powerful are the Roth conversion, life insurance, and IRAs payable to charitable remainder trusts. So I don't want to overstate the ability here to be able to get around the Secure Act or to somehow eliminate its negative ramifications. This is a very, very bad thing for clients and their children and other beneficiaries. But I think what you'll see through proper thought process and analysis, and I want to emphasize that again, analysis, I think you can minimize the impact of the Secure Act. So let's get into the solutions. First of all, here's a real quick view of the 2021 income tax rates for those of you who haven't looked at this in a while. I'd like to thank Jeff for getting these slides in here. And you can see we're still at the highest tax bracket of 37%. So as we talk about trusts, okay, as we talk about trusts, remember that income tax is either taxed to the trust or the beneficiary. So for those of you who may be really worried about that slide a few minutes ago that said with only $13,050 of income, the trust is in the highest tax rate. Remember that if we accumulate income inside of a trust and the income is not distributed out to the beneficiary, then we're going to be facing that highest income tax bracket at that very low threshold. But if income is distributed, there's an income tax deduction and the beneficiary reports the income on his or her own tax return. So just remember, whether it's a trust that holds retirement plan assets or whether it's a trust for non-retirement assets, a beneficiary or the trustee, I should say, of that trust has to manage the income tax consequences of that trust. But just because you see that high income tax bracket for trusts at a very low threshold does not mean the trust is going to pay that high tax rate down the road for every year. That is going to be managed by the trustee. The income, in most cases, is going to be distributed out to the beneficiary for their use and benefit, and that income is going to be claimed on their tax return. Now, we talked about that just a second ago. Here are those trust tax rates in 2021. So we have the individual tax rates, and then we have trust tax rates. So this is just for your review because these numbers tend to creep up a little bit over time, but we're still at 37%, even though we think it's going to go to 39.6. Now, what do we do here as we try to deal with the Secure Act? Well, if you can imagine this, imagine an IRA coming to a trust, and that trust is going to spray out IRA income to many, many beneficiaries. So let's say that this is just one strategy to think about. Let's say that instead of leaving an IRA to your 2 children or 3 children at the death of both of you if you're married, or at your death if you're single, what about leaving an IRA to the children, all of their children? And what we're doing here is we're getting income into the into various people's income tax brackets, not just 1 or 2 people. And in that way, we're spraying out more income. Now, we do have to be mindful of the kiddie tax issues and what the kiddie tax laws may be at that time. But the idea here is to get 10, 20, 30 people into this spray trust, if possible, depending on how many people are in your family, and get that IRA money distributed across many, many people's income tax bracket to lower the rate. And that is one way to deal with the Secure Act for certain people. Roth conversions. Many of you have Roths. Many of you are very familiar with Roth conversion. Many of you may be doing Roth conversions right now. Now, we're not talking about going out and doing a lump sum Roth conversion. So please don't run out and do that today. We're talking about a series of slow Roth conversions. We're talking about an analysis. We're talking about a lot of discussion. We're talking about how do I get my taxable IRA money into Roth category? How do I get it into a Roth so that when my children or other beneficiaries receive this IRA, they are not going to be taking this hit. I'm going to deal with it up front. And of course, I realize that Roth conversion analysis is not simple, and I'm just going to give you a few slides here in just a few minutes. So Roth conversion and back here to a multiple generation spray trust. These are 2 strategies, with Roth being one of the more powerful strategies. Here in this particular slide about the spousal rollover, I just want to bring to your attention that most people, married people, what do they do with their IRA or 401k? They leave it to their surviving spouse 100% in most cases. So all we're doing here is throwing out the idea that perhaps you wouldn't leave it to your surviving spouse 100%. Maybe you would leave some to your children. Now there's a lot of, or grandchildren, there's a lot of factors here. There is the pending tax laws, the exemption amounts and whether they're going to come down and so forth. But this is just the idea of maybe I won't leave everything to my surviving spouse. Maybe I will leave some to my children or grandchildren and be able to start the 10 years for them. These are the healthy, neurotypical children or grandchildren. And then my spouse, when he or she dies, they can leave also to the children and grandchildren and start a new 10 years. So there may be some advantage here in doing this, although some surviving spouses might not like the idea of not receiving 100%. So this is just one of the possibilities under the Secure Act. Leaving retirement plans to a charitable remainder trust. Now remember, a charitable remainder trust is a trust that can last for 5, 10, 15, or 20 years, or for lifetime. And this is a trust where the IRA would come into the charitable trust. Now, this is not going to be as powerful as leaving it outright to charity. It's not going to be as powerful as leaving it to your children and them being able to stretch it out for their lifetimes. But this is for the person who wants to simulate a payout to their children that would be somewhat similar to the payout that they could receive otherwise if the Secure Act had not happened. So this can simulate income payments to a spouse and then children, and then at the death of the children, the charitable remainder obviously goes to the charity. So this can be a very powerful strategy for those people who are charitably inclined. We're going to look at this a little bit more. and then leaving an IRA to a trust in a state where there is no state income tax. This is one particular possibility. And again, with the charitable remainder trust, the Roth conversion, and now next after these slides, the life insurance analysis, those are the more powerful strategies, but we want you to know that this is also a possibility. So let's look at life insurance, and these are fancy terms, the Roth conversion hedge and the IRA relocation. What we're really talking about here is using life insurance as a powerful tool to replace wealth that's going to take a hit at the passing of you or you and your spouse, and now the children are going to be subject to those accelerated tax rates right at the time possibly when children are at the highest earning capacity of their lives. And so life insurance can be a wealth replacement tool. So let's look at that in just a little bit. All right, so now going a little bit more in depth as I'm checking my time. It looks like we're a little bit before 11 o'clock. Jeff, as I head into the final series of slides here for the next 15 minutes, do we have any questions at this time?
Thank you, Steve. We do have a question, and it's a good one. The question is, my mother passed away in November 2019. Very sorry to hear that. I inherited a Roth IRA and a traditional IRA from her. The accounts were set up in my name in August 2020. Do I follow the new Secure Act rules or the pre-Secure Act rules?
That is an excellent question. So there is, I am always trying to find some humor in this, so bear with me. This strikes me as a question we sometimes get from veterans about the Vietnam era, and there was a pre-Vietnam era, and then there was the actual Vietnam era, according to the Veterans Administration. So this is one of those questions that is a very good one, and we do have answers, but what I would have to do to answer this correctly is, sir, or ma'am, if you would please email that question to Jeff and I, we will get back to you with an answer on that, because there are special rules. And as I just sat through the analysis discussion from Heckerling with Natalie Choate, she actually discussed this possibility about people who died in 2019, and there are special treatments of what law applies. So if you will please send me that question, and with the specifics, I will get back to you. Thank you very much for that. That is a very, very good question.
And so, Joe, the person that asked the question, I do have your contact information, and I will email that to Steve personally. So I will take care of that, and we will get you an answer very soon. So thank you very much for the question.
Yes, thank you. That is a great question. There are special rules that will apply for that period of time. Okay, Roth conversions. So I know we have a lot of financial advisors and maybe CPAs and others on the line here that deal with Roth conversions. So just remember that a Roth is 100% growth, tax exempt. There are no required minimum distributions at age 72 now under the Secure Act. And there are RMDs on inherited Roth IRAs and so forth, at least before the Secure Act. Now, I'm not going to go through these slides too much because of in the interest of time, and some of these are not going to be very effective as far as my ability to explain them to you in the limited time that we have. But just remember that the general concepts of Roth conversion are that a traditional IRA or 401k can be converted, 403bs and 457 plans. Non-convertible accounts, of course, are inherited IRAs and education IRAs. So someone who has special tax favored attributes such as charitable deduction carry forwards, investment tax credits, net operating losses, and so forth, those kinds of people should consider a Roth conversion, even if you had no other motivation based on what I've talked to you earlier about. Taxpayers who can pay the income tax on an IRA from a non-IRA asset enjoy a great benefit in Roth conversion. And so those who expect their income tax rates to increase in the future, okay? So general concepts. We don't want required minimum distributions to cause higher income tax rates in the future, increase capital gains rates, and so forth. And not only for beneficiaries in the future, but for yourself. So what we're going to see in these limited slides that I have is that there are certain math that has to be calculated. This is why at the beginning of this workshop, I'm encouraging you to sit with your financial advisor and CPA and estate planning attorney and work out this analysis to really look at the numbers. And the one thing that I want to show you here in this simple slide is that given the same rate of return and time for growth, a traditional IRA and a Roth IRA will come out the same. A lot of people are concerned that if I convert my Roth IRA, that I'm going to, take a big hit and I'm not ever going to recover. The truth is that given time, now that's where the risk is, given time and the same rate of return and growth, the Roth will do as well. Then your financial advisor will advise you better about this, but the Roth will do as well or better. So we do have an advantage if we die with a Roth, and if we die leaving a Roth to trust for children, or even if we don't leave trust, to leave IRA Roths to children and other beneficiaries because of the Secure Act issues. So this is just for your edification. Again, analysis is what is needed. There are certain mathematics of Roth conversions that we don't have the time or ability to get into today, but just to plant this idea that this is one of the powerful tools in your toolbox to be able to deal with the accelerated taxation and possibly the tax increases ancillary to the Secure Act. So without getting too much in depth, as we look at certain brackets and the ideas that we are trying to accomplish here with a successful Roth conversion, there is risk. There is risk that you would do a Roth conversion and die too soon, and that's what we're going to talk about next by using life insurance as a hedge and so forth. But all of this is in the analysis. I want you to know as you walk away from this presentation today that you don't have to feel helpless with all of these pending tax proposals and the Secure Act, which is already law. You do have the ability. You do have the ability to obtain analyses, to be able to have a step-by-step potential solution for how to deal with this, and just want to make that assurance to you. This is a lot more than just information. This is a call to action. So again, life insurance is a powerful tool. Many of you on this call are averse to buying life insurance, and of course we are advisors and counselors. We are not in the life insurance business. We have nothing to do with the life insurance business, but we do know that in estate planning, life insurance is a powerful tool. It creates a wealth replacement, and it preserves wealth where we're otherwise going to take big hits on taxation. So we want to talk about the Roth conversion hedge, and we want to talk about relocating assets to life insurance. So of course, the 10-year rule creates an actuarial risk, okay? And to make a long story short in these slides, because we're trying to wrap up on time here, we don't want the 10-year rule to unfairly tax people, especially your children, let's say, who are at their peak earning years, okay? And without life insurance to offset this risk, a lot of wealth could be lost. So the review of life insurance proposals is critical. Now, Roth conversions, as we just talked about, are a primary way to deal with this whole issue of the Secure Act and possibly other tax onerous tax laws. But the problem is that the effectiveness of the Roth conversion is going to be have to be offset with the thinking about what if I died too soon. So let's look at this last bullet point. A life insurance policy equal to the difference between the tax, okay, and the possibility of early death to offset that. That is what needs to be discussed. So many of you who have long passed the time where you might have considered life insurance as an income replacement may now need to look at life insurance as a wealth replacement. And that's what we want to encourage you to do. So therefore, there needs to be a policy structure with this kind of idea of a declining death benefit, for example. Let's say we do Roth conversion and we want to cover ourselves with a life insurance hedge strategy. So a whole life or universal life policy may be the best fit, but we are not financial advisors here at Elville and Associates, and we want to rely on your financial advisor, your life insurance specialist, and your advisory team with your CPA. Relocation is just simply the theory, a fancy way of saying we want to take IRA assets and relocate those IRA assets that may just be sitting there doing very well, hopefully, relocate those assets into life insurance to replace wealth that's going to be lost down the road. Now, this is for someone who is not necessarily going to do a Roth conversion. This is for the person that has a taxable IRA and there's going to be a lot of loss of income tax down the road. And so I think you understand what I'm saying. Here is an illustration that life insurance and all of these other strategies, given the same time of growth and so forth, will equal basically the same thing over time. But there are leverage strategies with life insurance that we strongly urge you to look at. Here's an example that is purely non-scientific, and Jeff and I were looking at a very complex illustration. We decided to save you the headache of looking at that massive illustration to simply try to take a very non-specific example. Here's an example of someone who, or a couple, then on the death of both of them, they're going to leave a $6 million IRA to their 2 children. And we know that at the end of 10 years, if those children have not taken out those IRA distributions for their inherited IRA, and I'm not saying that they would take no withdrawals, because maybe they will. Maybe they will be very smart and take some systematic withdrawals over those 10 years. And by the way, this is true whether or not the IRA is left in trust. But in this example, there's an IRA, $3 million each, that's left in trust for each child. So at the end of 10 years, they're going to be subject to a 37 or 39% tax bracket. This is not the correct number, but it's just for illustration. What if that couple took $30,000 out of their IRAs and purchased life insurance to offset the loss that each child is going to have? So we don't know if it would be $10,000, $30,000, $50,000 as far as the premium for this kind of life insurance, but we do know that it would be substantial amounts that would probably be necessary for the older couple or older person to purchase life insurance to offset the loss from the 10 years. So we just want to encourage you to look at life insurance as a powerful strategy that will actually equal the power of the Roth strategy, if not eclipse the power of the Roth strategy. Now, as we start to wrap up, and I know it's 10 after 11, I appreciate your patience in this very technical discussion. IRAs payable to charitable remainder trusts. So remember that a charitable remainder trust is one way that is considered to simulate the lifetime payout that was lost, to designated beneficiaries other than spouses, chronically ill people, disabled people, and minors, and people who are less than 10 years younger than the plan participant. Other than those people, meaning the vast majority of people, we're going to have a 10-year payout. So the charitable remainder trust, again, can be for a term of years, 5, 10, 15, 20 years for the person who is charitably inclined only. And then there can be income paid to the lifetime beneficiaries or the beneficiaries for the term of years. Now, the charitable remainder trust does not work well in every instance. Let's say you have young children that are in their teens or 20s. The lifetime payout does not necessarily work well. But if you'd like to see an illustration of the charitable remainder trust example, we're happy to get that to you based on your own circumstances. This is part of the analysis. And of course, you should have charitable intent to be doing this, because after the lifetime income, it's going to go to the charitable remainder. So a charitable remainder trust is one powerful strategy. And there are different types of charitable remainder trusts. There's a charitable remainder annuity trust and a charitable remainder unit trust. I won't spend a lot of time on this because we want to end on time. The charitable remainder unit trust, here's an example. The income beneficiaries receive a stated percentage of the trust assets every year. There are certain rules that have to be met. But the taxation of charitable remainder trusts, for those of you who are interested in this, it's a tiered taxation. So distributions are first taxed as ordinary income, then as capital gain, then tax exempt income, and then a non-taxable return of principal. So for those of you who are, and this is another illustration of that, for those of you who are charitably inclined, this can be a wonderful thing. It can also be a very powerful thing to deal with Secure Act. So again, in summary, a payment of the charitable remainder trust can be up to 20 years or for a lifetime, okay? For example, the trust pays 5% to a surviving spouse and 5% to children for their life, with the balance to charity. So one way of thinking about this is kind of like a marital trust where the assets go into a holding pattern that create income, and then all of a sudden we have the charitable remainder that goes to charity. So there's no taxable income to beneficiaries until they receive a distribution, and it's not quite as good as the wealth preservation of the 10-year Secure Act payout, but it's close, and it's for someone who is charitably inclined. And as you'll see in the best case scenario in the bottom, the best use of this strategy is where we have a payout strategy for someone who will receive a payout for 30 to 55 years. But if it's longer than that, it tends to diminish the viability of the strategy. So I thank you for your attention. I know that's a lot to go through. I wanted to give you background as we went through, not just the 5 or 6 solutions that you can look at, but we want to think in terms of next steps. We want to set a time to meet, to talk to you about estate planning. The accumulation trust change to certain trusts that have trusts for children and grandchildren that have conduit provisions. Those are pretty straightforward to make that change. But the broader issue is meeting with your financial advisor, CPA, and estate planning attorney to really develop a broad plan. And this is not easy to do. We're all busy today. You're very busy in your own lives. But we have to take the time to analyze these particular solutions. They're not simple solutions, most of them, and to see whether they're viable, you have to look at analyses. So we encourage you to, reach out. Let's meet. Let's get the advisory team going, and let's huddle around your situation, and let's see what the solutions are and how viable a particular solution may be for you, so that you can be proactive. And then I say, and as I end, I'll say we at Elville and Associates, and I'm sure many of you on this call, are going to continue to analyze and review the Biden administration changes and the committees that are meeting right now to review all of the proposals and formulate, I guess, what will ultimately be the final version of the American Families Plan that President Biden is proposing. And we're going to have to see where the political winds go with that. But we do know the Secure Act is here. We know the rules are there, the law is there, and we have to juxtapose that with the new laws that are coming to increase tax, and also the particular things that may be retroactive back to the fall, hopefully not retroactive back to January of 2021. Hopefully going forward, these new laws, whatever they may be, will be January 1st, 2022. But do the review, do the analysis, and do the planning during 2021 is what it looks like is the best approach. So with that said, we are at 11:15. I want to make sure we end on time. And Jeff, I'll turn it over to you. And again, I thank everybody for sitting through, what is probably a pretty dense presentation on a Wednesday. Thank you for being here.
Well, thank you, Steve. As always, really comprehensive and important information for everyone that's attending. And we do have a couple of questions that have come in, and I'll go ahead and pose them to you before I offer a few final thoughts. And the first one is from a good financial advisor that we have known for a while. Hi, Joe. It's good to remotely see you. And good question. Can the charity in a charitable remainder trust be a family foundation?
That's a great question. I don't know if my initial reaction is to say yes, but family foundation rules are very strict, and I would like to double check on that with you, Joe. But I think my initial reaction is it could be yes. That's my first reaction.
Okay, we will double check on that answer, Joe, and get that to you a little bit later here. So thank you for that question. Another question we have here, how likely is it that the cap for inheritance tax will be drastically reduced, as hinted at early on, to 3.5 Fed and or 1 million state of Maryland?
That's a great question. So we've been looking at this, like many of you have, since the summer and prior to the elections of last year. So initially, leading up to the end of 2020, there was massive speculation that there would be retroactive estate tax reductions in the exemption amounts. And I want to just clarify one thing about the question. I understand what you're asking, but remember, there's a difference between the inheritance tax, which is 10% in Maryland. And Maryland is one of the only states that has a state estate tax and a state inheritance tax. And inheritance tax only applies basically to non-lineal descendants. I believe that you're asking about the estate tax, but I understand what you mean. It's a death tax. The likelihood was thought to be very great in the early part of the year. But as time has gone by and Senator Sanders' proposal is on the table, now the American Families Plan is on the table, we actually think it's less likely that there would be a reduction to 3.5 million as per Senator Sanders' proposal, because surprisingly, the American Families Plan right now doesn't seem to contemplate that, as written up by Forbes and the other reports that we're getting. So I think it's probably going to be revisited in the fall, or maybe by January 1st, 2022, and maybe the reduction is going to be revisited. But I think the current feeling is right now that it may be left alone. It may be reduced down to 5.5 million, because remember, the Tax Cuts and Jobs Act of 2017 and the sunset of the estate tax exemption is January 1st, 2026, regardless of any legislation that's on the table now. So the 11.7 million exemption is slated to come down to 5.5 million, roughly, indexed for inflation on January 1st, 2026, even if there is no reduction in the estate tax exemptions now. So I think we can safely assume there will be tax law changes. They may be more focused on corporations and corporate tax and individual tax rates, and the elimination of the step up in basis, unfortunately capital gain, hopefully with some exceptions and exemptions there. I think it would not be surprising for the rates, the exemption amounts, to drop to 5.5, but I think we are thinking less about the 3.5 million reduction than we were 2.5, 3 months ago. So no one really knows. My personal opinion is it very well may be reduced to 5.5 million by January 1st, 2022, or it may be left alone as a political compromise in light of massive changes in the income tax.
Okay, very good. So this is the time of the webinar where I would say now is your time to get those final questions in if you do have them. A couple final thoughts. So Steve, over past several months, has written a few articles about the Secure Act, and if he thinks it's a good idea, I will go ahead and send out the links to those articles for you as additional resources, along with the link to today's video, and I'll send out the slides as well to you again if for some reason you did not receive them and could not download them for some reason. Also, our Elville webinar series on next Tuesday, June 1st, hard to believe it's already June, protecting and dealing with your digital assets. That is a new topic. All of us have more digital assets than we think, a lot more. and this is going to dive into that. And it's a very comprehensive discussion presented by Charles Borick, who is a remarkable attorney and is of special counsel here to Elville and Associates, and we are really excited for this topic. So hope you can register. I'll send out a link in my post-webinar follow-up email. I always send out Tuesday the 15th, VA aid and attendance, a tax-free pension for those that qualify. That's offered by Lindsay Moss, who is our senior elder law attorney here at the firm. And on Wednesday, June 16th, from Steve, learn what elder law attorneys are advising clients in 2021. Always a popular discussion. Also, a couple days ago, we were very pleased to send out, finally, after a lot of work, many months of work, we were pleased to send out our semi-annual newsletter, the 15th edition of the Elville Benefactor. So if for some reason you did not receive the electronic version of the newsletter, please let me know. I want to make sure that you got it. We put a lot of time and effort into it and hope you find it to be a great resource to you. We produce it entirely in-house, and so if you didn't get it, let me know. I'll be happy to send you the link to it. And if you want hard copies of it, I'd be happy to send you one or as many as you'd like to send out to family and friends, put on the table, put on the refrigerator, what have you. So, and the last thing is, also, yeah, if you want to go to our website to get the newsletter, you can go to elvilleassociates.com, click on the blog and media section, and click on the newsletter option, and it's right there at the top. So you can just click on it there as well. So with that being said, let's see if there's any final questions. And it looks like we do have two more. Let's see here. Okay, yeah. Okay, a follow-up question from Joe, the financial advisor that we know. I'll not say his last name to out of respect for him. So the idea regarding his last question, the idea would be to transfer highly appreciated assets to avoid the loss of the step-up basis, as well as IRAs, and possibly get the estate value down below exemption, replace the wealth loss with insurance so family gets the same wealth and avoid estate tax plus creation of the foundation. So that's a little bit of background, and I can go ahead and email that information to you as well, Steve,
Yes.
as you research the answer to that question.
Yes,
so
thank you
for that information.
Yeah, thank you, Jeff, and thank you, Joe. So upon further reflection, I was revisiting your question in my own mind, and now thank you for the supplemental question. I don't think you can transfer a foundation into a charitable remainder trust necessarily, but I'm going to research that. You definitely can transfer highly appreciated assets into a charitable remainder trust, and of course avoid the capital gain. So I'll await your question, and it's a great situation for the client. Sounds good.
Okay, and last question here, it looks like, if we have had trusts set up by Elville and Associates, do we need to schedule time to evaluate whether the Secure Act would cause any changes for us? That is a great question.
Yes, thank you for that question. And the answer is yes, because depending on what we did in those trusts will depend on whether any document changes need to be made. And if there is a need to make a document change, those are usually pretty straightforward changes with regard to dealing with the Secure Act. And regardless of document changes or not, that meeting would be a great place to start the conversation of, okay, what analyses do we need to look at to see if we're interested in doing anything unrelated to documents as far as dealing with the tax implications of Secure Act.
Okay, very good.
And I just want to say, Jeff, before you end, I just want to say something I didn't say, which is I wish everyone a happy Memorial Day weekend, and I hope you have a lovely holiday weekend. Go ahead, Jeff.
Yes, yes, so thank you. And we are on a Wednesday, and the weekend is slowly coming on the horizon. So I do also wish you all a very happy Memorial Day weekend, and hope you get through the rest of the week smoothly. So thank you for being part of our Elville webinar series. We hope you found this information valuable and informative to your situation. Reach out to us with any further questions. And if you want to set a time to meet with us, we're always available here as a resource, and we'll be happy to be of service to you. So thank you again for being here, and we hope you have a wonderful rest of the day. Take care. Thank you.